Is a holographic will a valid legal document? Imagine writing a quick note on a scrap of paper and calling it your last will and testament. Could that really be enough to decide who gets your belongings after you pass? Today, we're going to explore whether a holographic will can be a valid legal document. A holographic will is a will that is entirely handwritten and signed by the person making it, known as the testator. Unlike formal wills, it doesn't need witnesses or notarization in many states. But whether it's valid depends a lot on where you live. Some states recognize holographic wills, while others do not. In states that accept holographic wills, the entire document must be written in the testator's handwriting. This means no typing or printing. The signature must also be in their own handwriting. Some states requiring the will to be dated, but others do not. If the will isn't dated, it might be harder to prove it's the most recent version. Witnesses are a big factor. In states that do not requiring witnesses for holographic wills, the will can be valid without anyone else present. But if witnesses are needed, they must usually see the testator sign or acknowledge the will. Without witnesses, the court might question whether the handwriting and signature are genuine. The will must clearly show the testator's intent. This means it should name who gets what and state their wishes clearly. If the language is vague or confusing, the court might have trouble enforcing it. Also, the testator must be mentally capable when creating the will. They need to understand what they are doing and the consequences. Because holographic wills lack formalities, they can be more vulnerable to challenges. Probate courts might requiring handwriting analysis or testimony from people who knew the testator well. This can make the process more complicated and uncertain. Different states have different rules. For example, Texas allows holographic wills if they are handwritten and signed, with no witnesses needed. Florida generally requires formalities like witnesses, so a holographic will might not be valid there unless it meets those standards. Some states even allow holographic wills only for active military personnel or in emergencies. From an elder law point of view, it's often safer to use a formal will prepared by an attorney. Formal wills follow state laws and are less likely to be challenged. They also clearly state your wishes and are easier to probate. So, to answer the question directly, yes, a holographic will can be valid if it meets your state's specific requirements. But because laws vary and challenges can arise, it's usually better to have a properly drafted will. This way, your estate plan is clear, legal, and easier for your loved ones to carry out.